Good morning, and welcome to this Friday's edition of the Special Education News Roundup, brought to you by myself, Jennifer O. Price, Principal Attorney at the Law Office of Jennifer O. Price. This week, I'm talking to you about school discipline. Now, discipline is an issue, especially with children with disabilities, because far too often, schools want to discipline students for behavior that may be consistent with that child's disability. And in a school in Delaware, they did just that. There is a school district in Delaware called the Smyrna School District, where a 16-year-old got into a physical fight with another student. And along with being disciplined by the school, the student was also charged criminally with disorderly conduct and resisting arrest. Now, thankfully, the criminal charges were ultimately dismissed in family court, but the disciplinary matter still remained. So the school had a hearing, an expulsion hearing, and I'm going to give you some of the details of that expulsion hearing because they are very, very important, both on the appeal and both for what to bring out today. At the expulsion hearing, the principal did not testify. The principal claimed that there were also two witnesses to the fight who were present but did not testify. And then the officer who was present for the fight did not testify. So exactly how was the school board able to render a decision about whether to discipline and how? Through reports. The witnesses wrote out witness statements, and those statements were allowed to be admitted as evidence. The police officer who did not testify wrote a police report, and his police report was able to be admitted as evidence. And the assistant principal read various reports, including a written report by the principal himself. So I want to just take a quick pause right here to question how important was this really? I mean, no one thought that it was important enough to appear and testify or require people to appear and testify. It's really quite unbelievable, especially considering that the end result was that a 16-year-old child got expelled from school for 1 full year. Now, thankfully, his parents appealed, and they appealed to the Delaware Board of Education, which ultimately overturned the school board's decision. And the school then appealed to a court, a state court, and a judge agreed with the State Board of Education as well. Why? Well, first of all, it's significant that no one appeared to testify because everyone has the right to question or what's called cross-examine their witnesses. A school can't just rely on written reports to justify expelling a kid. Secondly, the school tried to expel this child for fighting when this was his first offense, and their own code of conduct does not require expulsion for fighting when it's your first offense. This was something else both the state board and the court did not take too kindly to. So some of the lessons learned are certainly obviously keep fighting. I mean, this was a mom who didn't have a lawyer at the disciplinary hearing. She then appealed to the State Board of Education, and once it got into their hands and the school appealed to a state court, then the mom in state court was represented by by a lawyer from the Department of Justice. So definitely keep fighting. But an even bigger issue or lesson to learn from this case is that expulsion hearings are treated just as significantly and importantly as being in state court. So if the rules of evidence that apply in a criminal case if you've been charged with a crime, or in a civil case if you're suing for money, apply also in an expulsion hearing. Even though you're in what seems to be an informal setting, the rules of evidence still apply. So you have the right to cross-examine your witnesses, you have the right to an attorney, you have the right to what's called confront your witnesses, and you can't just enter in reports that when the witness is available to testify as opposed to reading out the report. All of these rules of evidence are just as applicable in an expulsion hearing, just as the way they would be in a criminal court hearing or in a civil lawsuit. So that is the important takeaway from this matter. Try to learn the rules of evidence, get an attorney, or try to learn them yourself, because if you don't like the end result of an expulsion hearing, that decision can get appealed to a state court, which is why these hearings are extremely, extremely important. That's it for today. Have a great weekend.